Thank you for visiting the Combs Waterkotte website and taking the time to listen to our free legal audiobook, How a Criminal Defense Attorney Can Protect Your Rights and Future. Combs Waterkotte specializes in defending individuals facing severe criminal charges in Missouri. We've published this ebook to help you understand the criminal court process, build a solid defense, and protect your rights. With extensive experience in criminal defense law and over 10,000 cases handled, we can guide you through every step, from understanding the initial charges to preparing you for trial. This free ebook from Combs Waterkotte walks you through every step of the criminal defense process. Learn why acting fast is crucial, what qualities to look for in a lawyer, key questions to ask during a consultation, and red flags to avoid. With this book, you can get the knowledge you need to make an informed decision and protect your rights. With the introduction out of the way, let's get started. Chapter 0. Introduction. Whether you're facing criminal charges for the first time or you have prior experience with the legal system, the challenges ahead can be overwhelming, with the fear of losing your freedom, damaging your reputation, or carrying a criminal record for life is daunting. At Combs Waterkotte, we recognize the seriousness of your situation and are here to protect your rights and future. This ebook, How a Criminal Defense Lawyer Can Protect Your Rights and Future, is designed to guide you through the Missouri criminal justice system, highlighting how a skilled attorney can be your strongest advocate at every step. Here's how a lawyer can help. The criminal justice process. Your attorney will guide you through each stage, ensuring your rights are upheld from arrest to verdict. Long-term consequences of a criminal conviction. A lawyer helps mitigate the long-term impacts of a conviction, from protecting your record to preserving your future opportunities. Understand your legal rights. Your lawyer ensures that you fully understand your rights and that they are protected throughout your case. Interrogation, arrest, and booking. A lawyer can prevent you from self-incrimination and challenge any unlawful actions taken by law enforcement. Arraignment and pretrial motions. Your attorney will fight to dismiss charges, suppress evidence, and influence the direction of your case before it even reaches trial. Plea bargains and negotiations. Skilled negotiation by your lawyer can lead to reduced charges or sentences, securing the best possible outcome without a trial. Build a strong defense. Your lawyer will develop a defense strategy tailored to your case, challenging the prosecution's evidence and protecting your rights. Represent you in court. During trial, your lawyer advocates for you, presenting evidence, cross-examining witnesses, and striving for a not guilty verdict. Sentencing and post-trial actions. If convicted, your lawyer will work to reduce your sentence and explore options for appeal. Expungement. Your attorney can help clear your criminal record, offering a fresh start and restoring your rights. How to choose the right criminal defense lawyer. This chapter guides you on selecting the best legal representation to ensure your rights and future are protected. With the right criminal defense lawyer, you can navigate these challenges, safeguard your rights, and work towards a brighter future. This ebook is your first step in taking control of your situation. Always consult with an experienced criminal defense attorney to ensure the best outcome for your case. Chapter 1. The Criminal Justice Process. No matter the severity of your charges, the criminal proceedings process in St. Louis or elsewhere in Missouri can be complicated and daunting. The consequences of a criminal conviction can be severe. Whether this is your first offense or you have an extensive record, understanding the criminal justice process in Missouri is crucial for anyone involved. Combs Waterkotte, the leading criminal defense law firm in St. Louis and throughout Missouri, is here to assist you every step of the way. Our specialized criminal defense lawyers based in St. Louis have a combined 50 years of experience handling cases throughout Missouri, just like yours. You need that kind of knowledge and perseverance on your side. The criminal justice process in Missouri. When facing charges from a St. Louis or Missouri prosecutor, specific rules under criminal procedure must be followed. Typically, there are 8 steps in the process, though this list is not exhaustive. Some cases may involve fewer steps, while others may be more complex. Regardless of the case's specifics, your legal defense team should be committed to ensuring that all procedural steps are followed to safeguard your constitutional rights, protect your family, and secure your future. The 8 stages of the Missouri criminal justice process. Understanding the stages of the criminal justice system in Missouri is crucial for anyone facing charges. By doing so, you and your criminal defense attorney can better prepare for each of the criminal proceedings processes and work toward a favorable outcome in your case. 1. Arrest and booking. The criminal justice process typically begins with your arrest. Law enforcement officers can arrest you if they have probable cause to suspect that you have committed a crime. Following the arrest, you will be taken to the police station for booking, where your personal information is recorded, fingerprints and photographs are taken, and the charges against you are documented. 2. Initial appearance and bail. Following the booking process, you are required to appear before a judge or magistrate for an initial hearing, usually within 24 hours. During this session, the judge will outline the charges, your rights, and the possible penalties. The judge may decide to grant bail, considering the severity of the alleged offense and the probability of your return to court as required. For more severe offenses, the judge might order detention without bail. Alternatively, for less serious charges, or if you have no criminal history, the judge may release you without bail or on your own recognizance. 3. Arraignment. This initial court appearance marks the formal presentation of charges against you, where you will be asked to enter a plea of guilty, not guilty, or no contest. A knowledgeable defense attorney can always support and guide you through this challenging phase. During this appearance, the judge will schedule trial dates, set deadlines for motions, and establish other procedural timelines. While your legal team should strive to resolve your case without going to trial, they should also be fully prepared for any eventuality. The American Bar Association outlines 3 key criteria that must be met before a prosecutor can file criminal charges. There must be a reasonable belief that the charges are substantiated by probable cause. The evidence available must be sufficient to support a conviction beyond a reasonable doubt. The decision to proceed with charges must align with the interests of justice. 4. Preliminary hearing. In felony cases, a preliminary hearing is held to assess whether there is adequate evidence to advance to trial. During this hearing, the prosecution will introduce their evidence and witnesses, while your experienced legal team will have the opportunity to cross-examine witnesses and present your own investigatory evidence. If the judge determines there is enough probable cause, your case will proceed. The goal is to present sufficient counter-evidence to potentially have your charges dropped. 5. Pretrial motions and discovery. Before the trial begins, the prosecutor and your defense attorney participate in the discovery process, where they exchange evidence and witness lists. During this phase, both sides may also file motions to resolve various legal matters, like excluding evidence, dropping charges, or changing the trial venue. Additionally, this is commonly when plea negotiations take place. Depending on specifics, your criminal defense lawyers might be able to file a motion to suppress evidence obtained in violation of your rights, possibly inadmissible under the exclusionary rule. The judge will rule on the motions during pretrial hearings. Sixth trial. You are entitled to the right to a speedy and public trial under both state and federal law. In Missouri, you can choose between bench trials and jury trials. During the trial, the prosecution presents its case first, followed by our presentation of evidence, witness testimonies, and arguments. The jury, or judge, will then deliberate and deliver a verdict of guilty or not guilty. Seventh, sentencing. If you are convicted, the judge will set a sentencing hearing. At this final stage, the judge will evaluate several factors, including the severity of the offense, your prior criminal record, and any mitigating factors. Based on this assessment, the judge will determine your sentence, which could involve incarceration, fines, probation, or community service. 8. Appeals. After a conviction, you have the right to challenge the verdict or sentence through an appeal. This process is managed by an appellate court. To proceed, your appeal must identify specific errors or abuses of discretion made by the trial court. If the appellate court finds substantial mistakes, it may overturn the conviction or order a new trial. Chapter 2. Long-term consequences of a criminal conviction. A criminal conviction has far-reaching consequences on a person's life. This includes social stigmas, financial implications, legal troubles, and other fallout if they are convicted. Below is more information about convictions, what they are, and how they impact suspects and convicted criminals. What is a conviction? A conviction is a formal judgment by a court that declares a person guilty of a criminal offense. This determination follows a legal process where evidence is presented and evaluated, either in a trial by jury or judge, or through a plea agreement. Once convicted, the defendant faces sentencing, which can include penalties such as prison or jail time, probation, fines, or community service. The conviction becomes part of the individual's criminal record, potentially impacting their future opportunities and rights. It signifies that the legal system has found sufficient proof of the individual's guilt beyond a reasonable doubt. Consequences of being convicted of a crime. Here are a few of the consequences of being convicted of a crime. Incarceration. Depending on the severity of the crime and judgment, you may be sentenced to jail or prison. Jail is usually reserved for misdemeanors and holding, while prison is usually for felony-level crimes. Probation. A person may be placed under probationary status whether or not they went to jail or prison. In Missouri, you would have to report in to a probation officer, maintain a job, or even take drug tests. Criminal record. Having a criminal record can affect multiple aspects of a person's life. Any crimes are accessible to law enforcement, the public, landlords, employers, and other entities. This can include names and aliases, arrest charges, warrants, convictions, fingerprints, and mugshots. Some of the more serious implications include loss of rights. In Missouri, convicted felons lose their right to vote, own firearms, work in the public sector or hold office, travel out of the country, or even get a driver's license. Employment challenges. An undisclosed criminal record is grounds for termination in most workplaces. This becomes more complicated when people are job hunting, and the employer runs a background check. Another drawback may be a barrier for receiving certain professional licenses. Housing. It can be difficult to rent, or even buy a house if a person has a criminal record. Landlords are free to run a check and deny an application. It's advised to send the landlord a note beforehand, so it doesn't come as a surprise. This also applies to public housing assistance opportunities. Education. Like with housing, there may be barriers to education. This includes both admissions and financial aid opportunities. Immigration consequences. Convicts that are non-citizens in the U.S. may face deportation or be unable to apply for citizenship. Certain crimes may put a convict on sex registry lists that can impact employment, housing situations, and their personal image. Monetary restitutions. Depending on the judgment, you may owe fines for property damage, medical expenses, pain and suffering for any victims, or court fees. Community service. Standard for most misdemeanors or ex-felons, community service can range from dozens to hundreds of hours of street cleanup, volunteering, or other activities that are monitored by the court or probationary officer. Financial consequences. Criminal record checks that block employment opportunities means reduced earnings across the board. A convict may also have court-sanctioned legal fees, damage to their credit score, interest-based loans that have built up while incarcerated, and other fines. Personal consequences. An overlooked consequence is the stress and anxiety behind having a record or being convicted in the first place. A conviction may cause severe strain on friend and family relationships, reputation, and other social stigmas. How can a lawyer mitigate long-term effects of a criminal record? A convict's record isn't necessarily permanent. Following certain guidelines or meeting benchmarks after jail, prison time, or probation, it's often possible for criminal defense attorneys to expunge a record so it is no longer available to the general public or affects the ex-convict in any way moving forward. There are other ways to mitigate the consequences of having a criminal record. This includes plea bargains. A defendant's criminal attorney can negotiate with the prosecution and offer a plea deal to reduce charges and felonies into a misdemeanor. A misdemeanor, being a minor crime, is easier to get expunged. Expungement. To remove a conviction from the public record, lawyers can file for expungement or request that the criminal record is sealed. Diversion programs and conditional discharge. If it's a convict's first charge, criminal defense lawyers can advocate for rehabilitation and charge dismissal. Conditional discharges require that a defendant meets certain goals and can have their charges expunged after a period of time. Challenging the court. A defendant's attorney can challenge an arrest and charges based on evidence suppression, invalid arrests, and other circumstances that may lead to a case dismissal and a criminal record being redacted. They can also defend you at trial and question whether or not that state has enough evidence to convict you beyond a reasonable doubt. There are other methods legal teams use to either reduce or entirely expunge a defendant's criminal record. Felonies are more complicated to erase, but it's possible with some felonies if a defendant has the right legal team. A skilled attorney can provide valuable advice, represent the suspect in court, and work to achieve the best possible outcome. You can read more about expungement in Chapter 10. Chapter 3. Understand your legal rights. Your rights when charged with a crime are not abstract concepts. They are specific laws that dictate specific steps and actions in the United States and Missouri criminal process. A skilled criminal defense lawyer can help you understand these rights and how to use them to reach the most favorable outcome possible in your case. Your criminal defense lawyer is there to ensure that you fully understand your rights and to make sure these rights are upheld at every stage of your case. By knowing and exercising these rights, you empower yourself to make informed decisions that can significantly affect the outcome of your case. This chapter will explore your fundamental legal rights, how they can apply to your specific situation, and how your defense lawyer will protect and advocate for these rights to safeguard your future. Your rights in a criminal case in Missouri. The right to due process. Many of the following rights are based on the right to due process, which is a fundamental protection under the 14th Amendment, ensuring that you are treated fairly and justly throughout the legal process. This right guarantees that the government cannot deprive you of life, liberty, or property without following proper legal procedures. You are entitled to fair and transparent procedures at every stage of the legal process, from arrest to trial. While in some cases the state may hold you on bail, or, in extreme cases without bail, after charges are brought, the government must provide a fair trial before any significant penalties or restrictions on your freedom can be imposed, such as a prison term or fines. Due process applies at every step, ensuring that your rights are respected from the moment you are charged until the final verdict. Your lawyer will work to ensure that your case is handled with the fairness and justice that the law demands. The right to be informed of your rights, Miranda rights. Upon arrest, you have the right to be informed of your rights, commonly known as Miranda rights. As you've likely seen on Cops, Law and Order, and other shows, these include the right to remain silent and the right to an attorney. This helps prevent you from self-incrimination and, from the state's perspective, takes away an avenue where you could possibly seek a dismissal or appeal a trial verdict. If you were not read your Miranda rights, your criminal defense attorney can argue that any statements made during the interrogation should be excluded from evidence, as your rights were not properly communicated, and you, likey, did not have an attorney to represent you. The right to remain silent. The right to remain silent is one of your most powerful protections under the Fifth Amendment. Why it's important. Anything you say can be used against you in court. By remaining silent, your lawyer can manage what information is shared and when. How to exercise this right? Clearly state, I choose to remain silent and would like to speak with my attorney. If you don't express your right to remain silent, the state can use that silence against you in court. See Salinas v. Texas. Remain calm and avoid answering questions until your lawyer is present. The right to an attorney. The Sixth Amendment guarantees your right to an attorney, which ensures your criminal defense is not weakened by your lack of understanding of a complex system and series of laws. Why it's important. Your lawyer knows the law and can build a strong defense tailored to your case. An attorney prevents law enforcement from using coercive tactics against you during questioning. Request an attorney right away before answering any questions. If you're being questioned, firmly state, I want to speak with my attorney. If you ask for an attorney during an interrogation, law enforcement must cease questioning until an attorney is present to represent you. By invoking this right, you ensure that you have a knowledgeable advocate by your side, actively working towards the best possible resolution for you in your case. The right to be presumed innocent. The right to be presumed innocent is a cornerstone of the American legal system. This principle ensures that you are considered innocent until proven guilty beyond a reasonable doubt by the prosecution. This standard places the burden of proof on the prosecution, protecting you from wrongful conviction. You are not required to prove your innocence. Rather, the prosecution must prove your guilt. The prosecution must provide convincing evidence that establishes guilt beyond a reasonable doubt. This right is upheld from the moment charges are brought against you until the final verdict is delivered. Meaning, even if you have no evidence of your innocence and call no witnesses, your criminal defense attorney can still win your case by arguing the state's argument isn't strong enough. The right to reasonable bail. Under the Missouri Constitution, Article 1, Section 20, that all persons shall be bailable by sufficient sureties, except for capital offenses, when the proof is evident or the presumption great. Meaning, you have a right to reasonable bail to ensure that, if you are arrested, you have the opportunity to be released from custody while awaiting trial. Bail allows you to continue your life with minimal disruption, except in specific circumstances. Capital offense, or crimes for which a possible sentence is the death penalty. If you're deemed a public safety risk, if the alleged crime or your criminal history is particularly violent. If you're deemed a flight risk, possibly because of lack of ties to the community or previous instances of failing to appear in court. Repeat offenders or those with multiple charges pending. Serious felonies, especially those involving the use of weapons, sexual assault, or significant bodily harm. If you've violated previous bail conditions, while there will be stipulations attached to your bail, such as having to appear at all of your court hearings, bail allows you to hold on to your employment, housing, relationships, and most of your freedoms while you're awaiting trial. Your attorney can argue on your behalf that the exceptions don't apply to you, and can also argue for a lower bail amount if circumstances warrant it. Protection from unlawful searches and seizures. The Fourth Amendment protects you from unlawful searches and seizures, ensuring that law enforcement cannot invade your privacy without proper legal justification. This right is crucial in preventing the government from overstepping its bounds and infringing on your personal freedoms. Law enforcement must obtain a warrant or have probable cause to conduct a search, and evidence obtained through unlawful searches can be excluded from trial. Warrants under the Missouri Constitution. Article 1, Section 15. In order to receive a warrant from a judge, law enforcement must describe the place they want to search, the electronic data or communication they want to access, or the person or thing they are looking for. Probable cause. There is no specific Missouri or federal definition of probable cause. In Illinois v. Gates, the U.S. Supreme Court wrote that probable cause is a fluid concept based on the totality of circumstances. Generally, if police want to search you, your vehicle, or your home without a warrant, they must demonstrate that a reasonable and prudent person would think that a crime is currently happening or someone is in danger. Because the definition is fluid, an aggressive criminal defense lawyer may be able to argue in court to have any evidence taken without a warrant dismissed. The right to a fair trial. The right to a fair trial is a cornerstone of the American justice system, ensuring that you are judged impartially and based solely on the evidence presented in court. This right guarantees that you are treated justly and that the legal process is transparent and equitable. Key elements of a fair trial. Your case is heard by an unbiased jury that represents a cross-section of the community. You are given a fair opportunity to present your defense, confront witnesses, and challenge the prosecution's evidence. Ensures that only legally obtained, relevant evidence is used against you. Understanding and exercising your legal rights is fundamental to protecting yourself when facing criminal charges. Your criminal defense lawyer is your advocate, guiding you through these rights and ensuring they are fully upheld throughout the legal process. By working closely with your lawyer, you not only protect your immediate interests, but also safeguard your future. Chapter 4. Interrogation, Arrest, and Booking. The moments surrounding your interrogation, arrest, and booking are crucial. Understanding your rights during these critical junctures can significantly impact the outcome of your case. The skilled Combs Waterkotte criminal defense lawyers can advise you and protect your interests while interacting with law enforcement, safeguarding your rights and future. While these stages may seem daunting and overwhelming, our legal team's expertise is evident here. The Combs Waterkotte criminal defense attorneys have a combined 40 years of experience handling cases throughout Missouri, just like yours. Having this level of experience in your corner is irreplaceable. Interrogation. Knowing your rights. The interrogation process is a key moment in your criminal case. Law enforcement officers are essentially poking and prodding, using this opportunity to gather information and doing whatever they can to secure a confession. Not so fast. Police are legally allowed to lie to you to elicit a confession. But you still have rights that must be upheld, including the right to remain silent. Under the Fifth Amendment, you have the right to remain silent. You are never obligated to answer any questions without an attorney present. It's essential to clearly say, "I am invoking my right to remain silent and would like to speak to an attorney." The right to an attorney. Under the Sixth Amendment, you have the right to have an attorney present during questioning. Once you invoke your right to legal representation, the interrogation must cease until your attorney is present. The Miranda warning. Prior to any interrogation, law enforcement is required to read your Miranda rights, which do include the right to remain silent and the right to an attorney. If any officer fails to do so, anything you say may be inadmissible in court. How a criminal defense attorney can help during interrogation. Defense attorneys are experts in providing counsel during police interrogations, ensuring proper procedures are followed, guiding you on responses, preventing law enforcement from coercing or manipulating you, and, ultimately, getting you released as soon as possible. Arrest, the crucial moment. An arrest marks the formal point at which you are taken into custody. Nobody wants to be in this position. Having the guidance and compassion from an experienced criminal defense lawyer can make all the difference. After all, this moment is fraught with legal ramifications, and knowing your rights can protect you from unlawful practices. For an arrest to be lawful, law enforcement must have probable cause to believe that you have committed a crime. Without it, any arrest and subsequent evidence collected can be challenged in court. In addition to your right to remain silent and your right to an attorney during an arrest, the Fourth Amendment protects you from unreasonable searches and seizures. Any search of your person, vehicle, or property must be done lawfully. How a defense attorney can help during an arrest. A criminal defense lawyer can assess whether probable cause existed for your arrest, challenge any unlawful search or seizure conducted during your arrest, provide immediate legal advice to prevent self-incrimination, begin the process of building your defense strategy from the moment of your arrest. Booking, the formal process. Following an arrest, you will undergo the booking process at the police station. This involves recording your personal information, taking fingerprints and photographs, and logging the charges against you. While this may seem like a routine procedure from the outside, it is another crucial stage where your rights must be upheld. How a criminal defense attorney can help during booking. An expert criminal defense lawyer can ensure that the booking process is conducted lawfully and that your rights are protected. Work to secure your release on bail or your own recognizance. Argue for lower bail. Do whatever possible to get you out of jail. File a motion for an expedited hearing for your release. Interrogation, arrest, and booking are critical stages in the criminal justice process. A knowledgeable and experienced criminal defense lawyer is pivotal for navigating these stages, making sure that your constitutional rights are upheld, and laying the groundwork for a strong defense. Chapter 5. Arraignment and Pre-Trial Motions. An arraignment can lead to a number of pre-trial motions that are important to be aware of. The arraignment is the first step when the client is charged. However, pre-trial motions, see below, can prevent prosecutors from certain courtroom strategies. Once you are arraigned, you'll receive more court dates, perhaps a plea deal, and begin the procedural court process. What is arraignment? Arraignment is a court proceeding where a defendant is initially brought into court. The court arraigns the accused with criminal charges filed against them. Accusations are usually read aloud or written down and passed to the accused and criminal defense attorney. The primary goal of an arraignment is to inform a defendant of the charges filed against them in court. This is when you are able to say guilty, not guilty, or no contest. Depending on the charge, there will likely be a bail hearing that determines whether or not the defendant is a flight risk or a danger to others while other court matters are still pending. In a criminal case, arraignment is the first step where the defendant appears in court to hear the formal charges and may enter a plea. Your criminal defense lawyer will also address bail conditions and set timelines for the case's progression. Why would you be arraigned? The arraignment process is common for a number of different crimes. This step is often associated with criminal charges filed. An arraignment is required when an individual is formally charged with a crime, ranging from minor misdemeanors to serious felonies. Arrest and custody. After an arrest, the defendant is brought before a judge for an arraignment to be informed of the charges and to address bail or release conditions. Warrant issued. If a warrant is issued for someone's arrest and they are taken into custody or voluntarily surrender, an arraignment is held to initiate the legal process. Indictment by a grand jury. In serious crime cases, after a grand jury issues an indictment, the defendant is arraigned to formally enter a plea. Citation or summons. Individuals may receive a citation or summons to appear in court for certain offenses, where the arraignment allows them to enter a plea and set further proceedings. Probation violations. An arraignment may be held if someone is accused of violating their probation terms to address the alleged violation and determine the next steps. Failure to appear. If a defendant fails to appear for a scheduled court date, a bench warrant may be issued, and they will be arraigned on new charges related to the failure to appear, in addition to the original charges. These processes are put in place to protect a defendant's rights and privileges. The arraignment process. Typically, the order of operations includes 1. Pretrial motions. Your criminal defense lawyer will address legal issues before the trial even begins. Depending on the specifics of your case, they may argue for case dismissal, suppressing evidence, or changing where the trial takes place due to a number of factors. These motions are designed to protect an alleged criminal's rights and to ensure the process protects a defendant's rights. Criminal defense lawyers play a crucial role in the pretrial phase, especially when it comes to filing and arguing pretrial motions. These motions are legal requests made before the trial begins, aimed at shaping the trial's outcome or even preventing it from happening. There are a few common motions that can be requested before proceeding an actual trial. These include motion to dismiss. A motion to dismiss is a legal request made by the defense to have a case thrown out before it proceeds to trial. This motion is typically based on procedural errors, such as a violation of the defendant's rights, or due to a lack of evidence that fails to sufficiently link the defendant to the alleged crime. For instance, if the prosecution's case is fundamentally flawed, such as missing critical evidence or failing to establish probable cause, the defense may argue that the state does not have enough evidence to convict beyond a reasonable doubt. A judge may dismiss the charges altogether. Motion to suppress evidence. A motion to suppress evidence is a request to exclude specific evidence from being presented during trial. This motion is often filed when the defense believes that the evidence was obtained illegally, such as through an unlawful search and seizure, or if the evidence was tampered with or planted. For example, if drugs or a weapon were found in a manner that violates the defendant's Fourth Amendment rights, the defense may argue that this evidence should be suppressed, meaning it cannot be used against the defendant in court. Motion to change venue. A motion to change venue is for moving the trial to a different geographical location before case proceedings. This request is usually made when there is concern that a fair trial cannot be conducted in the original venue due to factors like extensive media coverage, public bias, or community sentiment that could influence the jury's impartiality. Motion in limine. A motion in limine is filed to request that certain evidence or information be excluded or limited before it is presented in front of a jury. This type of motion is often used to prevent potentially prejudicial or irrelevant information from influencing the jury's decision. For instance, if certain facts could unfairly bias the jury or lead them to make a decision based on emotion rather than fact, the defense may seek to have that information barred from the trial. The goal of a motion in limine is to ensure that the trial remains fair and focused solely on the pertinent legal issues. Motion to strike. A defendant has the right to motion to strike prior convictions from the trial. Other convictions may impact a jury's decision and allow the defense time to review the case and prepare. By filing and arguing one or any number of these motions, criminal defense lawyers work to protect the rights of their clients, weaken the prosecution's case, and set the stage for the best possible outcome at trial. Second, discovery process. The discovery process is a critical phase in criminal proceedings where both the defense and prosecution are required to exchange evidence, witness lists, and other relevant information related to the case. This phase is designed to ensure transparency, allowing both sides to fully understand the evidence that will be presented at trial. During discovery, legal teams gather crucial details like police reports, forensic evidence, witness testimonies, and more that could influence the outcome of the trial. The information exchanged during discovery allows the defense to identify any weaknesses in the prosecution's case and develop a robust strategy to defend their client. Similarly, it enables the prosecution to prepare counter-arguments and reinforce their case against the defendant. Discovery promotes fairness and makes sure that both sides are able to present their arguments. 3. Plea bargaining. The prosecution will often offer a plea deal, bargain, where the defendant has the opportunity to plead guilty to a lesser charge in exchange for reduced penalties. This can include a shorter sentence, reduced fines, or even the dismissal of certain charges in exchange for pleading guilty to other ones. Plea bargaining is a common practice as it can expedite the legal process, avoiding the uncertainty and length of a full trial. While this option may provide the defendant with a more favorable outcome, it's important for the defendant to review the terms of the deal thoroughly with their defense lawyer, as accepting a plea bargain also means waiving the right to a trial by jury and potentially accepting a criminal record. The decision to accept or reject a plea deal should be made with the guidance of an experienced attorney who can assess the strength of the prosecution's case and negotiate the best possible terms on behalf of the defendant. Fourth, trial preparation. If a plea deal is not reached, both the defense and prosecution will move forward with trial preparation following the arraignment. This process involves meticulously organizing and reviewing evidence, interviewing and preparing witnesses, and gathering character witnesses who can testify on behalf of the defendant. Both sides will also spend time crafting compelling arguments and developing legal strategies aimed at persuading the judge or jury. Additionally, this phase may include the filing of various pretrial motions to address issues such as the admissibility of evidence or to challenge the validity of the prosecution's case. The thoroughness of this preparation is crucial, as it sets the stage for how the trial will unfold and can significantly influence the outcome of the case. Court date. If the case proceeds, the court will schedule a specific date for the trial or hearing. It is crucial for the defendant to attend this court date, as failing to appear can have serious legal consequences. If the defendant misses the scheduled date, the court may issue a warrant for their arrest, commonly known as a bench warrant. This means that if the defendant is later stopped by law enforcement, such as during a traffic stop where their license is checked, they could be immediately taken into custody. Missing a court date can negatively impact the defendant's case, potentially leading to additional charges or penalties. Depending on the crime and its severity, there may also be a set bail either upon detainment and arrest or directly from a judge. Bail is typically set during the arraignment. During the arraignment, the judge will either set bail, release the defendant, or deny bail based on the charges. Arraignment in Missouri. In a criminal case, arraignment is a crucial initial step where the defendant appears in court to hear the formal charges and potentially enter a plea. It's at this stage you may want to hire a criminal defense attorney to help you through the process. To summarize, arraignment allows you and your legal team to look for inconsistencies, collect medical records, if applicable, decide what evidence can be presented, and can even lead to a case dismissal or sentence reduction. Chapter 6. Plea bargains and negotiations. Plea bargaining is a common component of the criminal justice system in Missouri, offering a means to resolve cases efficiently without the need for a full trial. Plea deals involve negotiations between the criminal defense attorney and the prosecutor, where the defendant may agree to plead guilty to a lesser charge or accept a reduced sentence in exchange for concessions from the prosecution. Depending on the specifics of your case, a plea bargain may offer you the best possible resolution while removing the hassle and cost of a trial for the state. In Missouri, plea bargains are frequently used to manage the heavy caseloads of courts and provide a quicker resolution to cases. However, the decision to accept a plea deal isn't an easy one and requires a thoughtful discussion with your defense attorney about the strength of the evidence, the potential penalties, and the long-term consequences of a conviction. An experienced criminal defense attorney can help you decide if a plea bargain makes sense for you. This chapter will explore the concept of plea bargains in detail, examining the benefits and drawbacks of accepting a deal, the possible outcomes of a plea deal, and how negotiations tend to occur. We aim to provide a comprehensive understanding of how plea bargaining works in Missouri and how it can protect the rights and future of those accused of crimes. What is a plea bargain? A plea bargain is an agreement in the criminal justice system where the defendant agrees to plead guilty to a lesser charge or accept a reduced sentence in exchange for concessions from the prosecutor. This process helps to avoid a lengthy and uncertain trial. In Missouri, plea bargains are a common tool to manage court caseloads efficiently and provide quicker resolutions for defendants. They can involve charge bargaining, where the defendant pleads to a less severe charge, or sentence bargaining, where the defendant receives a lighter sentence. Plea bargains can offer benefits to both the state and the defendant. They reduce the time and resources required for a full trial. Defendants receive a predictable outcome rather than risking a harsher sentence at trial. Similarly, the state is guaranteed a conviction where a not guilty verdict at trial is possible. Courts can allocate resources to more complex cases. Defendants can move forward with their lives more quickly. However, deciding to accept a plea bargain is not straightforward. It involves weighing the potential benefits against the drawbacks, such as having a criminal conviction on record, even if for a lesser charge. This is where the legal advocacy of an experienced criminal defense lawyer becomes paramount to your defense. Pros and cons of accepting a plea bargain. The exact benefits or drawbacks of a plea deal will depend on your specific charges, the evidence against you, and your life circumstances. Generally, pros: reduced charges. Pleading guilty to lesser charges can significantly reduce the severity of the penalties. For example, a felony charge that would carry jail time can be reduced to a misdemeanor and fines. Reduced sentences. Defendants can receive lighter sentences, such as probation instead of incarceration. This can mitigate long-term consequences, such as loss of employment opportunities or strain from being away from family. Quicker resolution. Plea bargains expedite the legal process, providing a quicker conclusion to the case. This can reduce the stress and uncertainty associated with prolonged trials. Certainty of outcome. Defendants know the exact consequences of the plea, avoiding the unpredictability of a trial. This can be especially beneficial when the evidence against the defendant is strong. Cons. Admission of guilt. Unless you receive a suspended imposition of a sentence, SIS, or suspended execution of sentence, SES, accepting a plea bargain involves pleading guilty, even if not to the original charge, which results in a criminal record. This can have lasting impacts on employment, housing, and personal relationships. Possible injustice. Innocent defendants may feel pressured to accept a plea deal to avoid the risk of harsher penalties at trial. This can lead to unjust outcomes where innocent individuals are convicted of crimes they did not commit. Limited appeal options. Pleading guilty typically limits the defendant's ability to appeal the conviction. This can be problematic if new evidence arises or if there were procedural errors during the case. Plea bargains require careful consideration and consultation with a knowledgeable criminal defense lawyer to ensure that your rights and future are adequately protected. Types of plea bargains. In general, prosecutors and criminal defense lawyers negotiate 4 different types of plea deals. Charge bargaining means negotiating to plead guilty to a lesser charge than originally filed. For example, a defendant charged with a felony assault may negotiate to plead guilty to misdemeanor public disturbance. Charge bargaining reduces the severity of penalties and the long-term impact on the defendant's record. Sentence bargaining means negotiating for a lighter sentence in exchange for a guilty plea. For example, agreeing to plead guilty with the understanding that the prosecution will recommend a reduced sentence, such as probation instead of jail time. Charge bargaining provides a more predictable and often less severe sentence. Alternative sentences may include suspended imposition of a sentence, SIS, suspended execution of a sentence, SES, house arrest, probation, fines and restitution, deferred adjudication, community service. Count bargaining involves negotiating to have some charges dropped in exchange for a guilty plea on remaining charges. For example, a defendant charged with 5 counts of theft agrees to plead guilty to 2 counts in exchange for the other 3 counts being dismissed. This reduces both the sentence and the number of convictions on the defendant's record. Fact bargaining involves negotiating certain facts to be omitted or agreed upon to avoid more severe charges. For example, a defendant agreeing to admit certain facts in exchange for the prosecution not presenting other aggravating facts. This can lead to reduced charges or sentences by limiting the scope of the case. Depending on the specifics of your case and life circumstances, your criminal defense attorney may seek to negotiate for one or all types of plea bargain. Alternative court programs. While some sentence reductions mean accepting probation or a short stint in jail over prison, Missouri also has several specialty programs for offenders who meet certain criteria and/or have specific needs. These programs aim to address the underlying issues contributing to criminal behavior, such as substance abuse or mental health disorders, providing an opportunity for a defendant to rehabilitate without being incarcerated. Missouri has 4 types of alternative courts Drug courts, treatment-based alternative for nonviolent drug offenders with substance abuse issues. Focuses on recovery and reducing recidivism, chances of reoffending, through supervised treatment programs. Re-entry courts manages the reintegration of individuals returning from prison. Utilizes court authority for sanctions and resources to support positive behavior and reintegration. DWI/DUI courts targets repeat DWI offenders, involves rigorous supervision, treatment, and regular court appearances. Mental health courts addresses the needs of individuals with mental health issues in the criminal justice system. Aims to reduce incarceration and recidivism by connecting participants with mental health services and support. Plea bargain negotiation process. The purpose of a plea bargain, from your and your criminal defense lawyer's perspective, is to secure the most favorable outcome in your case. Experienced defense attorneys should be willing to go to trial to defend you in court if they do not get an acceptable plea deal from the prosecution. Depending on your history and the charges against you, a plea deal may be agreed to quickly in a courthouse hallway, or may take months of aggressive negotiations by your defense attorney. The plea bargaining process begins with an initial assessment where the defense lawyer conducts a comprehensive review of the case, details, evidence, and potential defenses. During this stage, your defense lawyer will consult with you to discuss the possible outcomes, preferences, any mitigating circumstances that could influence the negotiation, and any concerns you might have. Your defense lawyer will then initiate contact with the prosecutor to begin negotiations. This phase is marked by a series of negotiations where offers and counteroffers are exchanged. The goal is to reach terms that are acceptable to both parties, balancing the state's interest in efficiently securing a conviction with your interest in getting the best possible resolution to your case. During the negotiation process, your criminal defense lawyer will advocate on your behalf, carefully evaluate each offer, weighing the risks and benefits of accepting the plea deal versus going to trial. This includes a thorough risk assessment, considering the strength of the prosecution's case, potential penalties, and the likelihood of a favorable trial outcome. Your defense lawyer will make sure you fully understand each offer's implications, providing clear guidance and recommendations. Though you alone will make the decision to accept the plea deal or not, an aggressive defense attorney experienced in your specific case type can be an invaluable resource and source of guidance. Often, a prosecutor sees you as simply a case number. Your defense attorney can present as a human being who is trying to keep their life from being derailed. Once a plea agreement is reached, the final step involves presenting the plea deal to the judge for approval. This stage ensures that the plea is legally sound and that the state has a record that you fully understand and consent to the terms. The plea deal is then documented, formalizing the agreement and concluding the negotiation process. Throughout the plea bargaining process, your defense lawyer's role is to advocate for your best interests and ensure a fair and just outcome. Factors to consider when negotiating for a plea bargain. Deciding whether to accept a plea bargain is a significant decision that requires careful consideration of multiple factors. As a defendant, you and your attorney need to evaluate the potential benefits and drawbacks thoroughly, as well as understand the long-term implications of your choice. Strength of the evidence. Prosecution's case. Assess the quality and quantity of the evidence against you. Strong evidence might make a plea deal more appealing to avoid harsher penalties at trial. Defensive strength. Consider the effectiveness of your defense strategies and any exculpatory evidence that could work in your favor. Potential penalties. Trial versus plea deal. Compare the possible sentences you could face if convicted at trial with the terms of the plea bargain. You may have to consider the risk-reward of being found guilty and having a heavier sentence at trial versus being found not guilty and receiving no sentence. Long-term consequences. Evaluate how the potential penalties of accepting or not accepting the plea deal will impact your personal, professional, and social life, including criminal records and future opportunities. Certainty of outcome. Predictability. A plea bargain offers a definite outcome, whereas a trial's result is uncertain and could be more severe. Emotional and financial costs. Consider the stress, time, and expense involved in going to trial versus the quicker resolution of a plea deal. Personal circumstances, employment, and family. Think about how prolonged legal proceedings might affect your job, family responsibilities, and overall well-being. Health and mental state. Consider the toll a trial might take on your physical and mental health. Eligibility for specialty programs. Alternative sentencing. Determine if accepting a plea bargain could make you eligible for specialty court programs, e.g., drug court, mental health court, that focus on rehabilitation rather than punishment. Program benefits. Assess the potential benefits of these programs, such as reduced sentences or dismissals upon successful completion. Legal advice. Defense lawyer's guidance. Rely on your criminal defense lawyer's expertise to understand the nuances of the plea bargain, the strength of the prosecution's case, and the likelihood of a favorable trial outcome. Informed decision. Ensure that you are fully informed about the legal implications, rights, and options before making a decision. Making an informed decision about a plea bargain involves balancing these factors with the help of a knowledgeable criminal defense lawyer who can guide you through the complexities of the legal process and advocate for your best interests. Chapter 7. Build a strong defense. When faced with any criminal charge, the basis of your defense can make the difference between freedom and conviction. You need the expert criminal defense attorneys at Waterkotte building your defense strategy to protect your rights and future. Having awareness of the common defenses available, along with the legal expertise to employ a variety of solid defense strategies, is a decisive advantage. Our defense lawyers have over 50 years of combined experience working cases just like yours and getting successful outcomes. Building a strong defense. Understanding the charges. The initial step in building a strong defense is fully understanding the charges against you. Criminal charges range from misdemeanors to serious felonies, each carrying its own set of legal definitions, penalties, and possible defenses. Your defense attorney will begin by carefully examining the charges, breaking down the legal language, and explaining what the prosecution must prove to secure a conviction. Each element of a crime, intent, causation, and harm, must be proven beyond a reasonable doubt by the prosecution. By scrutinizing these elements and identifying weaknesses or gaps in the prosecution's case, your attorney starts developing a targeted defense strategy. Building a strong defense. Investigating the case. A thorough investigation by an experienced defense team is the backbone of a strong defense. Your lawyer will work to gather all relevant evidence, which could include witness statements, surveillance footage, forensic reports, and any other materials that can shed light on the facts of the case. This process often involves interviewing witnesses, consulting with experts for testimonies, analyzing police reports/other documents. Our defense lawyers also conduct their own independent investigations, leaving no stone unturned in your defense and ensuring that every piece of evidence is meticulously examined and evaluated for its potential impact on your defense. Building a strong defense. Challenging the prosecution's evidence. One of the most effective ways to build a strong defense is by challenging the evidence presented by the prosecution. This can involve questioning the credibility of witnesses, highlighting inconsistencies in their testimonies, or disputing the reliability of forensic evidence due to how it was collected, handled, tested, stored, or presented. As an example, if the prosecution's case relies on eyewitness testimony, your lawyer might investigate the conditions under which the witness made their observations, like lighting, distance, and the presence of any distractions. Challenging the prosecution's evidence not only weakens their overall case, but also raises doubts in the minds of the judge or jury, which can be crucial in getting a favorable outcome. Building a strong defense. Developing a legal strategy. Once the evidence has been thoroughly investigated and analyzed, our criminal defense attorneys will craft a comprehensive legal strategy tailored to your specific case. This defense strategy may involve presenting an alternative narrative, asserting legal defenses, or negotiating with the prosecution for a reduced charge or sentence. Some common legal defenses our lawyers use, depending on the specific circumstances of your case, include self-defense. Arguing that your actions were justified to protect yourself or others from an imminent threat provides the basis for a strong defense strategy. Alibi. Demonstrating that you were somewhere else when the crime occurred, supported by credible evidence like witness testimony or surveillance video footage, is a strong defense. Lack of intent. If intent is a crucial element of the crime, we'll show that you did not have the required intent to commit the offense. Constitutional violations. If your rights were violated during the investigation, arrest, or trial, such as through an unlawful search or seizure, we may move to have the evidence suppressed or the charges dismissed. Your lawyer's defense strategy will also consider the potential for plea bargaining. In some cases, negotiating a plea deal with the prosecution may be in your best interest, especially if the evidence against you is strong. However, a skilled defense attorney will always weigh the pros and cons of an agreement and ensure that any decision you make is in your best interest. Building a strong defense is a complex and multifaceted process that requires expertise, diligence, and a deep understanding of the law. From the moment charges are filed, the criminal defense legal team at Waterkotte is your strongest ally, working tirelessly to protect your rights and secure the best possible outcome. Chapter 8. Represent you in court. Facing a criminal trial is one of the most daunting experiences anyone can endure. The stakes are incredibly high. Your freedom, reputation, and future are all on the line. If your case is not dismissed and you do not receive a favorable plea bargain before trial, with expertise of a seasoned Missouri criminal defense lawyer becomes invaluable, you can still have your day in court and have your freedoms protected. A defense attorney is not just your legal representative. They are your advocate, strategist, and protector. From the moment you step into the courtroom, their role is to ensure that your rights are safeguarded, that the prosecution's case is thoroughly challenged, and that the court and jury see you as a person, not just a case number. The trial is the culmination of all the preparation and hard work discussed in the previous chapter. Build a strong defense. Now, your lawyer will put that strategy into action to achieve a not guilty verdict. Stages of a criminal trial in Missouri. The stages of a criminal trial can generally be outlined as such: deciding whether you want a bench or jury trial, voir dire, jury selection, opening statements, presenting evidence, closing arguments, jury deliberation, and verdict. This chapter will guide you through the trial process in Missouri, providing insights into how your lawyer will represent you at every stage of a criminal trial. You'll learn about the key phases of a trial, the strategies your lawyer will employ, and how they will work tirelessly to achieve the best possible outcome for you. 1. Bench or jury trial. One of the first strategic decisions in your trial is choosing between a bench trial and a jury trial. Generally speaking, your criminal defense attorney may recommend a jury trial when your case largely comes down to a question of fact, or a bench trial if your case centers around a question of law. Jury trial. A question of fact changes from case to case and involves the actions and circumstances around the alleged crime based on the evidence presented by both sides. If your case hinges on a question of fact, your criminal defense lawyer may recommend a jury trial where a group of your peers would decide what occurred. Examples of questions of fact include determining whether a defendant was present at the scene of a crime, assessing the credibility of witnesses, and deciding whose testimony is more believable, determining if the defendant had the requisite intent to commit a crime, deciding if the defendant's alibi is credible and supported by evidence, deciding whether the defendant acted in self-defense during a confrontation. Juries are more likely to be swayed by emotional arguments or personal narratives, which can be advantageous in cases where the facts support a compelling story in your favor. It is also more difficult for the prosecution to get 12 people to agree on a fact as opposed to just one person, the judge. Thanks to the Sixth Amendment, anyone accused of a crime in the United States has a right to a jury trial over a bench trial if they so choose. Bench trial. A question of law involves the interpretation or application of legal principles, statutes, or rules. It refers to issues about what the law is, how it should be applied, or whether a particular rule of law applies to the case at hand. As opposed to questions of fact, questions of law do not change from case to case. Rather, they seek to address which elements of the law should be applied to a case. For example, if two or more laws conflict, the judge decides which one applies. Interpreting the meaning of a statute. Balancing the accused's constitutional rights with the state's right to prosecute a crime. In a bench trial, the judge alone decides the verdict. Judges are equipped to understand and apply legal principles without the potential biases or emotional reactions or misunderstandings of law that a jury might have. For example, in a bench trial involving a complex financial crime, where the case hinges on the interpretation of financial regulations or technical accounting details, a judge's expertise in the law can be advantageous. Judges are better equipped to parse through intricate legal arguments. In a standard jury trial, the jury decides questions of fact, while the judge decides questions of law. In a bench trial, the judge does both. Bench trials are also used in juvenile crimes and municipal offenses like traffic tickets. Your defense lawyer will carefully evaluate the nature of your case, the evidence at hand, and the likely perceptions of either a judge or jury. While the ultimate decision is up to you, an experienced criminal attorney's insights will be invaluable. Second, jury selection. If you opt for a jury trial, the 12 members of your peers chosen for the jury will decide your fate. Because of that, both the prosecution and defense teams participate in jury selection, known as voir dire, which involves questioning potential jurors to uncover any biases, preconceived notions, or personal experiences that might affect their impartiality. Your lawyer will look for jurors who can be fair and objective, but also those who might be more sympathetic to your defense. For example, if you are accused of drug manufacturing or drug trafficking, your criminal defense lawyer would likely challenge the participation of a juror who had a loved one who died of an overdose, while they may welcome the participation of someone with a loved one who successfully completed rehab and stayed clean. There are two types of challenges your criminal defense attorney can make in Missouri: peremptory challenges and challenges for cause. Peremptory challenges. These challenges mean that your attorney and the prosecution can each dismiss a juror without having to provide a reason to the court, with the exception of discrimination based on race, ethnicity, gender, or religion. See Batson v. Kentucky, in which the U.S. Supreme Court ruled that doing so violates the 14th Amendment. Under Missouri Revised Statute Section 494.480, the state and defense can each use 9 peremptory challenges in a death penalty case, 6 peremptory challenges in a felony case, 2 peremptory challenges in a misdemeanor case. Challenges for cause. A challenge for cause is when either the defense or prosecution asks the court to remove a potential juror from the jury pool because they believe the juror is not able to be impartial or is otherwise unfit to serve. The specific reason must be given to the judge, who has the final say in the dismissal. Examples include people who have a relationship with someone involved in the case, people who have prior knowledge of the case and have already formed an opinion, people whose life experience has created a strong bias towards an element of the case, or people whose religion or beliefs prevent them from following the law, as explained by the judge. Both the defense and prosecution have an unlimited number of challenges for cause. The goal during jury selection is to form a jury that is as unbiased as possible, or, at the very least, one that is receptive to the defense's arguments. Your lawyer's expertise in this phase can significantly influence the trial's outcome, making it a pivotal part of your defense strategy. Third, opening statements. The opening statement is the part of the trial where your defense lawyer sets the stage for your case. It's their first opportunity to present your narrative to the judge or jury and to shape how they perceive the evidence that will follow. Unlike closing arguments, opening statements are factual previews that outline what the defense intends to prove. Your lawyer will aim to present a coherent story that casts doubt on the prosecution's case, build trust with the jury by presenting facts clearly and confidently, highlight key pieces of evidence that support your innocence or create reasonable doubt. For example, in a self-defense case, the lawyer might emphasize the danger you were facing and the steps you took to protect yourself, setting the stage for later evidence that corroborates this narrative. In another case, they may present doubt that the prosecution's evidence is as good as they say it is. The goal is to leave the judge or jury with a clear understanding of your defense and to prepare them to view the prosecution's evidence with a critical eye. By establishing a strong foundation, your lawyer helps ensure that the jury is open to your side of the story as the trial unfolds. The prosecution presents their opening statement first, allowing your criminal defense attorney to attack the prosecution's case directly. In a recent Waterkotte victory in a sex crimes case, the prosecution had intended to use a felony conviction 15 years earlier against the defendant. We acknowledged the felony conviction and reiterated that it was irrelevant to the current charges and that the defendant had nothing to hide. Taking on that part of the state's argument head-on took the wind out of the prosecution's sails. 4. Presenting evidence. The bulk of the trial is made of each side, the prosecution first, presenting their witnesses and evidence, while the other side has an opportunity to dispute those claims. Presenting evidence is a pivotal phase of the trial where your defense lawyer actively builds your case by introducing evidence that supports your innocence or raises reasonable doubt about the prosecution's claims. This process involves several key steps. Cross-examination of prosecution. Witnesses. Your lawyer challenges the credibility and reliability of the prosecution's witnesses through strategic questioning. Example: highlighting inconsistencies in a witness's testimony or exposing potential biases. Defense evidence presentation. Your lawyer introduces evidence such as documents, physical evidence, and witness testimony that supports your defense narrative. Example: providing an alibi through witness testimony or presenting physical evidence that contradicts the prosecution's claims. Expert testimony, utilizing experts to provide specialized knowledge that can challenge the prosecution's evidence or support the defense's theory. Example: a forensic expert might testify that the physical evidence was mishandled, that forensic methods used by the prosecution were flawed, or that the forensic evidence is inconclusive. Objections and protecting your rights. Your lawyer actively monitors the prosecution's presentation of evidence, objecting to any improper or illegally obtained evidence. Example: objecting to the introduction of hearsay or evidence that was obtained without a proper warrant. Throughout this process, your lawyer's goal is to systematically dismantle the prosecution's case while reinforcing your defense narrative, ensuring that the judge or jury sees the weaknesses in the prosecution's evidence and is persuaded by the defense's arguments. Remember, your criminal defense attorney doesn't have to prove your innocence, just that there is reasonable doubt in the prosecution's version of events. 5. Closing arguments. Unlike the factual preview provided in the opening statement, the closing argument allows your defense lawyer to interpret the evidence, persuade the jury, and make a compelling case for why the evidence presented should lead to a not guilty verdict. The closing argument is the final opportunity for your defense lawyer to address the jury or judge, summarizing the evidence and reinforcing the key points of your defense. This phase is vital in shaping how the jury interprets the information presented during the trial. In closing arguments, your criminal defense lawyer may summarize the defense case. Your lawyer will revisit the central themes of your defense and explain any new evidence presented at trial, highlighting the evidence that supports your innocence or casts doubt on the prosecution's case. Example: emphasizing the lack of direct evidence linking you to the crime or pointing out lack of motive. Reinforce reasonable doubt. The lawyer will stress any gaps in the prosecution's case, underscoring the principle that the burden of proof lies with the prosecution. Example: arguing that your DNA's presence at a crime scene could be the result of trace DNA. Humanize the defendant. Your lawyer may appeal to the jury's emotions by reminding them of your character, background, and the impact that a guilty verdict would have on your life. Example: highlighting your positive contributions to the community, lack of previous criminal convictions, or the potential consequences of a conviction on your family. Address the jury instructions. The lawyer will guide the jury on how to apply the judge's instructions to the facts of the case, emphasizing legal standards and how the facts of your case fit or don't fit the definition of certain laws or instructions. Example: in a self-defense case, your attorney will tie legal standards for terms such as reasonably believes and imminent use of unlawful force to what happened in the moment. Offer a final appeal. In the closing moments, your lawyer will make a compelling appeal for acquittal, urging the jury to deliver a verdict based on fairness, justice, and the evidence, or lack thereof, presented during the trial. The closing argument is designed to leave a lasting impression on the jury, tying together all the elements of the defense to advocate for your acquittal. It's the culmination of your criminal defense attorney's efforts to protect your rights and secure the best possible outcome. 6th Jury Deliberation and Verdict. After receiving the jury instructions, the jury retires to deliberate in private, discussing the evidence and arguments presented during the trial. During this phase, the jurors assess the credibility of witnesses, the strength of the evidence, and apply the legal standards provided by the judge. Under both U.S. and Missouri law, all 12 jury members must reach a unanimous verdict. If they cannot, they must notify the judge, who will either send them back for more deliberations with more instructions or declare a mistrial. While your criminal defense lawyer can't do more to influence the jury once deliberations begin, they will prepare you for any possible verdict: guilty, not guilty, or a mistrial. This includes discussing potential next steps, such as appeals or retrials if necessary. The jury's decision is announced in court. If the verdict is not guilty, the case concludes, and you are acquitted. If the verdict is guilty, your defense attorney can begin planning post-trial motions or sentencing strategies. Chapter 9. Sentencing and Post-Trial Actions. Chapter 10. Expungement. Being convicted of a crime may feel like a permanent stain, but for certain offenders convicted of certain crimes, the state of Missouri offers expungement, which some states refer to as record sealing. Expungement seals or destroys criminal records. While law enforcement and certain government agencies will still have access to your records, expungement hides your record from public view, and you can legally state that you have not been convicted of the expunged crime. Expungement offers a fresh start and a chance to overcome the barriers posed by past offenses, including improved employment opportunities, better housing options, and restored rights. 4 types of records in Missouri. In Missouri, there are 4 primary types of records that can be considered for expungement. Each type of record has its own unique implications and impacts on an individual's life, and its own eligibility requirements. Expunging a driving record. Your driving record includes any traffic violations or DWI/DUI offenses. Minor traffic violations. Certain minor traffic offenses, such as speeding or minor accidents, can be expunged. Eligibility generally requires a clean record for a specified period and no subsequent violations. Alcohol-related offenses. First-time DWI offenses may be expunged under specific conditions. Missouri law allows expungement if it is a first-time offense. 10 years have passed since the completion of any related sentence, including probation, or no other alcohol-related driving offenses have occurred during that time. General eligibility criteria. No commercial driver's license at the time of the offense, and the offense did not involve a DWI accident or result in injury. Expunging an arrest record. Even if you are not charged or convicted of a crime, the record of your arrest will still be available to the public unless you have it expunged. Arrest records can be expunged in 2 cases. If you were arrested, but no charges were filed, you may be eligible for expungement. This typically involves filing a petition and demonstrating that you meet the criteria set by Missouri law. If the charges were dismissed or you were acquitted, you can apply for expungement. Missouri law requires that you wait a specific period, generally 3 years, without any subsequent criminal convictions. Eligibility criteria. No felony conviction in the past 3 years, no pending charges at the time of the expungement petition, and demonstrating that expungement is consistent with the public welfare. Expunging a criminal record. The record of your criminal convictions is held by the National Crime Information Center, NCIC. Under Missouri Revised Statute, Section 6, 10.140, Missouri law allows for misdemeanors and some felonies to be expunged. Misdemeanors. Many misdemeanors are eligible for expungement. Under Missouri law, you must wait 3 years after completing your sentence, including any probation or parole. For example, minor theft or drug possession offenses may qualify. Felonies. Certain non-violent felonies can be expunged after a 7-year waiting period post-sentence completion. This includes offenses like certain drug possession or property crimes. However, violent felonies, sexual offenses, and crimes involving minors are typically ineligible. Specific exclusions: Class A felonies, such as first-degree murder. Any dangerous felony, as defined by Missouri Revised Statute, Section 556.061, including violent crimes and domestic violence. Any offenses requiring sex offender registration. Felony kidnapping. Multiple DWI/DUI offenses, or a DWI/DUI offense with a CDL. Crimes involving endangering the welfare of a child. Political crimes. Illegal abortion. Certain financial crimes. Expunging DSS, Department of Social Services, and CPS, Child Protective Services. Records. Records related to Child Protective Services, CPS, investigations can be more complicated due to the fact that victims or alleged victims are spouses and children. Expungement is typically more restrictive and may involve different procedures. Unsubstantiated reports. Reports where there is not enough evidence to prove abuse or neglect occurred. These can be expunged immediately or within 5 years. Probable cause findings. There is enough evidence to believe abuse or neglect likely happened, but it is not definitive. These are retained for 10 years from the date of the report. Preponderance of evidence findings. There is more evidence for than against the occurrence of abuse or neglect. These are retained until the youngest child in the report turns 28 or 10 years, whichever is longer. Court-adjudicated reports. A court has legally determined that abuse or neglect did occur. These reports are retained indefinitely. For all expungements, the process typically involves filing a petition with the court, providing notice to relevant parties, and possibly attending a hearing. Legal advice from an experienced criminal defense attorney is recommended to navigate the specifics of Missouri's expungement laws and to ensure eligibility. What does demonstrating that expungement is consistent with the public welfare mean? Demonstrating that expungement is consistent with the public welfare means showing that clearing a person's record will not harm society and may even benefit it. This involves proving that, in addition to meeting the technical requirements, you have been rehabilitated and are unlikely to commit future offenses. It also includes demonstrating that the expungement would help you reintegrate into society, such as by improving employment opportunities or housing prospects, and that maintaining the record serves no significant public interest. Here are some key points typically considered. Rehabilitation evidence. The individual must show they have been rehabilitated. This could involve evidence of stable employment, community service, or positive contributions to society since the offense. No further offenses. The individual should have no further criminal activity or arrests since the original offense. This period can vary, but is typically several years. Impact on employment and housing. Showing that the expungement will help the person find better employment or housing, contributing to their stability and reducing the likelihood of reoffending. Public safety considerations. Demonstrating that expunging the record does not pose a risk to public safety. For instance, simple possession of a controlled substance might be eligible for expungement. If the individual was found possessing drugs near a school, the court might find that expunging the record would not be consistent with public safety due to the heightened risk to the community. Judicial discretion. Ultimately, the judge has the discretion to decide whether expungement serves the public welfare, balancing the individual's need for a clean record against any potential risks to the community. This process often requires a formal petition and sometimes a hearing where you and your expungement attorney can present evidence and arguments supporting your case. The expungement process in Missouri. The process for expunging a record in Missouri involves several steps, each requiring careful attention to detail to ensure a successful outcome. The expungement process in Missouri typically happens in 4 steps. Filing a petition. To initiate the expungement process, the individual must file a petition in the circuit court of the county where the offense was adjudicated. The petition should include details about the offense, your criminal history, and reasons why the expungement should be granted. The petition forms can be found on our Missouri Criminal Defense Resources page, on the Missouri Court's website, and here, Petition for Expungement of Arrest Records. Petition for Expungement. Section 6, 10.140, Revised Statutes of Missouri. Petition for Correction of Arrest to Court Records. Identity theft. Petition for expungement, mistaken identity. Petition for expungement. Marijuana-related offense or serving notice. The petition must be served to various parties, including the prosecutor, the law enforcement agency involved, and any victims of the offense. Court hearing. After the petition is filed and served, a hearing will be scheduled. During the hearing, the judge will consider factors such as the nature of the offense, the individual's behavior since the conviction, and the impact of the expungement on public safety. The burden of proof is on the petitioner to show that expungement is warranted. Court decision. If the court grants the expungement, the records will be sealed. While the record is sealed from public view, law enforcement and certain government agencies can still access it. How a criminal defense lawyer can help with your expungement. Even if you believe you meet all the requirements for expungement, it's never advisable to enter a petition or go to court without at least consulting with a criminal defense attorney first. Here's how a defense attorney can assist you. Assessing eligibility. A criminal defense lawyer will review your case to determine if you are eligible for expungement under Missouri law. Not all offenses are eligible, and specific conditions must be met. Your lawyer can help you understand if your conviction qualifies and what steps need to be taken. Gathering necessary documentation. The expungement process requires detailed documentation, including court records, proof of payment of fines, and other relevant information. A lawyer will assist you in gathering all the necessary documents and ensure they are correctly filed. Filing the petition. Filing for expungement involves submitting a petition to the court, which must include all pertinent details of your case. A criminal defense lawyer will draft and file the petition on your behalf, making sure it meets all legal requirements and increases the chances of approval. Representing you in court. If a hearing is required, your lawyer will represent you in court, presenting arguments on why your record should be expunged. They will advocate on your behalf, countering any objections from the prosecution or other parties. Navigating complex legal procedures. Missouri's expungement laws can be intricate, with various timelines, forms, and procedures that must be followed. A criminal defense lawyer will navigate these complexities, ensuring that everything is handled efficiently and correctly. Improving the likelihood of success. Having a lawyer increases the likelihood of a successful expungement. They will know how to present your case most effectively, addressing any potential issues and advocating for your best interests. Expunging your criminal record in Missouri is a significant step toward regaining control over your future. With the help of an experienced criminal defense lawyer, you can navigate the process with confidence, increasing your chances of a successful outcome and allowing you to move forward with a clean slate. Chapter 11. How to choose the right criminal defense lawyer. When facing criminal charges, deciding on the right criminal defense lawyer can be one of the most important choices you ever make. The outcome of your case can hinge on the skill, experience, and dedication of the attorney representing you. You deserve one of the attentive and aggressive lawyers at Combs Waterkotte on your side. No matter the severity of your charges, an attorney is your advocate in the legal system, responsible for protecting your rights, presenting your defense, and guiding you through the complexities of the criminal justice process. This chapter will help guide you through the process of choosing the right attorney, providing you with the tools and insight needed to make an informed decision. How to choose the right criminal defense lawyer. Before diving into the selection process, it's good to fully understand the role of your criminal defense lawyer. After all, you not only have the constitutional right to an attorney, you also have the right to counsel of your own choosing. A good attorney will break down the charges against you. Your lawyer will analyze the legal elements of the charges and assess the strength of the prosecution's case. Develop a defense strategy. Based on the totality of the evidence, your defense lawyer will craft a strategy aimed at achieving the best possible outcome. Whether that means dismissal of charges, a favorable plea negotiation, or a successful defense at trial. Represent you in court. Your attorney will represent you from pretrial motions to trial proceedings, challenging the prosecution's case and advocating on your behalf. Important qualities to look for in a criminal defense lawyer. Selecting the right criminal defense lawyer involves evaluating a number of key qualities, including experience and expertise. Criminal law is a complex field with intricate statutes and laws, and each kind of charge requires a specific skill set and knowledge. For example, an attorney with decades of experience in DUI/DWI cases may not be the best choice for a white-collar crime. Look for a lawyer who specializes in criminal defense. An attorney who focuses exclusively on criminal defense will be more up-to-date on the latest legal developments, tactics, and trends in this area of law. Has experience with your specific charges. If you're facing drug possession charges, find an attorney who has successfully defended clients against similar allegations. If you're charged with a violent crime or a gun charge, look for someone with a proven track record in that area. Is willing to take your case to trial. You need a law firm on your side that has experience trying cases and is willing to do that in yours. Settling or caving to the prosecution isn't always the best option. Is familiar with local courts and prosecutors. A lawyer who knows the local legal landscape, including the judges and prosecutors, can offer valuable insights and potentially leverage those relationships to your advantage. Reputation and track record. An attorney's reputation within the community and with past clients can provide valuable insight into their effectiveness and professionalism. Consider client reviews and testimonials. Read reviews and testimonials from past clients to gauge their satisfaction with the attorney's services. Peer recognition and awards. Lawyers who are recognized by their peers through awards or professional associations often have a strong reputation in their field. Track record of success. While past results don't guarantee outcomes, especially considering every case is different, an attorney with a history of successful outcomes, particularly in cases similar to yours, inspires confidence. Communication and accessibility. In any successful attorney-client relationship, effective communication is crucial. You need an attorney who will keep you informed, answer your questions, and be accessible when you need them. Evaluate their clarity and transparency. Does the attorney explain legal terms, concepts, and procedures in a way that you can understand? Do they clearly outline their strategy and what to expect? Availability. Will the lawyer be available to take your calls and meet with you? Do they respond promptly to emails or messages? Client-centered approach. A good attorney will listen to your concerns, involve you in decision-making, and respect your input. Steps to take in choosing the right criminal defense lawyer. Once you've identified the qualities that ring true with you, follow these steps to pick the right criminal defense lawyer. 1. Research and compile a list of potential lawyers. Start by researching lawyers in your area who specialize in criminal defense. You can use online directories, bar association referrals, and recommendations from friends or family members. Compile a list of potential candidates based on their experience, reputation, and specialization. Schedule initial consultations. Set up consultations to meet with lawyers, discuss your case, and evaluate their suitability. You should be looking for a free, no-strings-attached consultation where you can discuss the specifics of your case and get expert legal advice and guidance on next steps. Prepare a list of questions to ask during the case review, like, what is your experience with a case like mine? What defense strategy would you recommend for my case? What are the possible outcomes, and how likely is each? How do you charge for your services, and what will be the estimated total cost? 3. Assess comfort and confidence. During the consultation, assess how comfortable you feel with the lawyer. Do they listen to your concerns and your side of the story? Do they explain things clearly? Do they inspire confidence in their ability to handle the intricacies of your case? Trust your instincts. 4. Make an informed decision. After meeting with several lawyers and gathering all necessary information, take the time to compare your options. Consider the attorney's experience, reputation, communication style, and fees. Choose the lawyer who best aligns with your needs and gives you the most confidence in their ability to protect your rights and get you the best possible outcome. Finding the right criminal defense lawyer is a crucial decision that can significantly impact your case. It could very well be the difference between freedom and jail time. By understanding the qualities to look for, the right questions to ask, and carefully evaluating your options, you can find an attorney who will provide the skilled and dedicated representation you need. Chapter 12. Skilled Criminal Defense Attorneys in Action. Combs. Waterkotte's criminal defense attorneys have a demonstrated track record of obtaining favorable outcomes for those facing a variety of criminal charges. Here are a few real-life examples of how a defense attorney can protect your future and freedom. Second-degree domestic assault. A St. Louis County man was charged with domestic assault in the second degree, a Class C felony. While the case was pending, the client was charged with kidnapping in the second degree and another count of felony domestic assault. After a comprehensive review of the evidence and plea negotiations, Combs Waterkotte was able to secure a dismissal for the kidnapping and domestic assault, and the client received probation on original charges. Second-degree murder. St. Louis County. Man charged with murder in the second degree after another man died in a fight at a St. Louis County bar and grill. After an extensive review of the evidence, Combs Waterkotte got the charges reduced to manslaughter, and our client received probation, 2 weeks' time served, and 60 days house arrest. Fourth-degree domestic assault. A Lewis County woman was unjustly charged with domestic assault fourth degree after an altercation with her boyfriend, who had been drinking. Combs Waterkotte immediately began working to get the case dismissed. By applying the right amount of pressure, along with corroborating evidence, the prosecuting attorney dismissed the case. Assault first and ACA Combs. Waterkotte represented a Barnhart man charged of assault in the first degree and armed criminal action. The state alleged our client engaged in a road rage incident with the victim and fired a single gunshot at the victim. Following a jury trial, our client was found not guilty. Burglary. Combs Waterkotte represented a 17-year-old St. Peter's resident who was charged with burglary, a Class C felony, which carries a maximum penalty of up to 7 years in prison. The state alleged that our client, along with 2 other individuals, broke into a home and stole more than $3,000 in cash and goods. One of our client's alleged accomplices was not criminally charged in exchange for his testimony against our client. The other co-defendant, who was represented by another attorney, had already pled guilty. Despite the fact that the cooperating witness admitted to breaking into the home with our client, we were able to thoroughly discredit his testimony at the preliminary hearing. The judge did not find probable cause and dismissed the case. Felony child abuse. Combs. Waterkotte represented a St. Charles man in St. Charles County Circuit Court on a charge of felony child abuse and domestic assault. Felony child abuse carries with it a mandatory minimum 1 year of jail time and a maximum of 7 years in prison. Our client was alleged to have beaten his child with an oversized mallet and then striking his wife. 1 week before trial, our client received a favorable plea deal that included both charges being reduced to misdemeanors and being placed on probation for 2 years. Felony drug possession. Combs Waterkotte represented an Atlanta man on 1 count of felony drug possession in Montgomery County Circuit Court. Our client, who was not a U.S. citizen, was facing mandatory deportation if he pleaded guilty or was found guilty of a felony drug offense. After intense pretrial investigation, we were able to uncover flaws with the lab drug reports and convince the prosecutor to dismiss the case. Felony stealing. Combs Waterkotte represented a North County woman on 2 felony counts of stealing a credit device and 1 count of felony stealing in St. Louis City Circuit Court. At the time Combs Waterkotte was retained, our client was locked up in Chicago waiting to be extradited back to St. Louis. We immediately got to work for our client, and not only was able to secure our client's immediate release, but also convinced the prosecutor to dismiss the charges against our client within 24 hours of being hired. Forcible rape. Combs. Waterkotte was retained immediately by a Bonne Terre man after he was charged with forcible rape. The state alleged our client raped a female acquaintance after coming home from a bar with her. After a 3-day jury trial, the jury found our client not guilty. Making a terrorist threat. Combs Waterkotte represented a St. Louis County juvenile charged with making a terrorist threat, which is a felony crime. The state alleged our client wrote several bomb threats in the restroom stall of our client's high school. After a trial, our client was found not guilty. If you or a friend, loved one, has been charged with a crime in Missouri, Combs Waterkotte's defense attorneys are happy to discuss your case with you at no charge. You can visit our website, fill out our online contact form, or give us a call at 314-900-HELP for a free consultation.